Meeting now streaming live on YouTube.
All right.
We are now on the air.
Why is it all the slowest computers in the building ended up on the corporate?
We're on YouTube. We're on YouTube now.
Oh, nice. We're on YouTube.
Meeting now streaming live on YouTube.
All right.
We are now on the air. Daniela is
Why is
linking
it all
her
the
attorneys
slowest
in.
computers in the building ended up on?
Okay, I've muted the YouTube.
Okay.
There shouldn't be any feedback.
Okay.
Should I admit the attorneys now?
Did we do our mic check?
Mic test hasn't been done yet.
Okay.
Those of us in broadcasting.
All right, this will be quick now that the computer's in.
I got you over here, even though it's only one mic we need.
Okay. Oh, caps lock.
Hit that one.
Sidebar.
Second defendant's mic, second plaintiff's mic, second judge's mic, second witness mic.
Skipping the jury box.
Yes. There you go.
Thank
Got
you.
that one.
I brought my own headphones.
Daniela, do you have attorney's video or via phone?
One's using an iPad, but I think the other two are using computers.
Okay, cool. So presumably all via video then.
Yes, it should be.
You ready to go?
Is this Kenrock versus Barrison or some?
Yes.
Oh, it is? Okay. It's listed as a motion here, right?
Well, functionally, it's the same thing. It's a return of an order show cause.
Oh, okay. I'm going to start the record now for everyone. I think we're all set up.
Okay, starting the record now.
All right, I'm letting them in.
Great. Okay, so good afternoon, everybody. My name is Judge McGovern. This is in the matter of Lauren Kanarek, K-A-N-A-R-E-K, versus Michael Barrison, Sweetgrass Farms LLC, Ruth Cox et al. Under Morris County Superior Court docket number MRS-L-2250-19. And I see we have several attorneys with us. Good afternoon once again. Could you please enter your appearances?
Good afternoon, Your Honor. Andrew O'Connor from Nagel Rice on behalf of the plaintiff.
Good afternoon, Your Honor. Chris Dininger from Dininger and Associates on behalf of Barrison.
Good afternoon, Your Honor. Mark Silver from law firm of Coughlin Duffy on behalf of Sweetgrass. Just observing.
Thank you. Anybody else participating? I know John Graves, Esquire, filed an appearance on behalf of Ruth Cox, but as far as I know, he's not participating. Perhaps he's listening in, or he'll check it out later on YouTube. So this is the return date of an order show cause brought by plaintiff counsel on behalf of Lauren Kanarek, returnable today, originally at 11 o'clock, moved to 1:30 p.m. for obvious reasons. And I appreciate everybody's cooperation in being punctual and participating by way of Zoom. And this is our first Zoom virtual court hearing, at least for Judge McGovern, if not for you, gentlemen. So welcome aboard. And again, this is the plaintiff's application. I've reviewed all of the materials filed on behalf of the plaintiff. I've reviewed the papers filed on behalf of Mr. Barrison by Mr. Dininger. And so first we'll hear from Mr. O'Connor on behalf of the plaintiff.
Thank you, Your Honor. And we appreciate you taking us like this. Let's talk about what's undisputed in this case. What's undisputed is that Mr. Barrasone had one of his associates illegally bring a firearm into the state of New Jersey. He then took that firearm to the plaintiff's residence and at that time confronted her and then shot her twice. This is all undisputed, okay? Without a doubt, we will ultimately succeed on these claims. Now, it's interesting, in their reply papers, or in their opposition papers, defendant Barrasone says, well, I shot her, but she was a bad tenant, or I shot her, but she wasn't a good person. None of those are defenses in this case, and the facts are undisputed. He shot her. There's no battered landlord excuse or anything like that. So ultimately, when you look at the elements of Crow, number one, there'll be irreparable harm if his assets are frozen. Two, the law is well settled in our favor. Three, undisputed that we're ultimately going to win this case. And number four, balancing the relevant hardships. All we're asking is to maintain the status quo. All we're proposing is that a fiscal agent be appointed so that Mr. Barrasone can't dissipate all of his assets while this case is pending. Especially here where we have a situation where it's unlikely that Mr. Barrasone will have insurance that will cover many of his actions, many of the torts that he has. And the only remedy that the plaintiff's going to have is against his personal asset. Now, we understand that he's trying to sell the property to which he's owner of the horse farm. We understand there's another chancery action right now pending to determine who owns what of that and to try and get that sold. We also understand that Mr. Barrasone has several horses that he's already moved out of state. All we're asking is that the fiscal agent be appointed to maintain the status quo so that all of his assets are not dissipated while this action is pending, Your Honor.
All right, thank you, Mr. O'Connor. And Mr. Deininger?
Thank you, Your Honor, and thank you for the opportunity to participate for the first time over Zoom. Your Honor, nothing could be further from the truth as to what was just said. Mr. Barrasone's not trying to sell the farm. Mr. Barrasone's fighting the sale of the farm. There's no evidence before this court of any attempt by Mr. Barrasone to make himself judgment-proof as to Ms. Kinnerack. And yes, the material facts are heatedly in dispute. For counsel to suggest that nothing's in dispute and he's assured a win here is just simply incorrect based on the pleadings. Even a cursory review of the pleadings demonstrates that. Liability is contested, and this is going to be a case that's going to have to go to trial. And what is the status quo? The status quo isn't some sort of a guarantee for a litigation plaintiff to have a claim or control over someone else's assets. That's flatly contrary to New Jersey law. We have the case of Delaware River and Bay Authority, which, although it's not binding on this court because it's a Chancery Division case, it is an articulate, in-depth analysis of the issue demonstrating why the relief that is sought here by Ms. Kinnerack is not available to her now. She has no right of attachment under the New Jersey attachment statute. She has no special relationship like an escrow agreement where she gave money to somebody and then someone's trying to dissipate it, which is what happened in the Delaware River and Bay Authority case. And she's an ordinary litigant and she has to prove her case. And she has no evidence before this court, competent or otherwise, to support her application. Thank you, Your Honor.
Mr. O'Connor, anything further?
No, I know Your Honor has read the papers. Look, we do know that the property is trying to be sold right now. And if Mr. Barrasone is allowed to take, I believe they tried to list it, Your Honor.
Well, trying to list it and listing it are two different things. I understand the Chancery action. Mr.
Your Honor,
Are you who's representing Mr. Barrasone in the Chancery action?
I am, Your Honor.
Yeah, and Your Honor, I can give a little more information on that aspect of it. Again, Mark Silver on behalf of Sweetgrass. Mr. Deininger is correct in that there is a dispute. Sweetgrass, the LLC, and the other members of the LLC, the Lundbergs, want to sell the farm and escrow the proceeds. There is a dispute between those parties in front of Judge Berderty Byrne. She has ruled, at least for the next 8 weeks, that we are not allowed to sell the farm. There's discovery going on. in that case, but at least for the next 8 weeks, we are barred from attempting to sell the farm.
But Your Honor, in any event, even if there's a sale of it ordered by the judge, as you just heard Mr. Silver say, the proceeds are going into escrow.
Okay, I don't know what of course, that would be something to be determined, I suppose, down the road. I'm sure, I shouldn't say I'm sure about anything, but I will guess that the terms of any escrow or limitations on what use those funds would be available for or not have yet to be spelled out. So the real estate in Chester, the property at Sweetgrass Farm, I'm not aware if Mr. Barrisone has other property or real estate interests. The record is really pretty barren in terms of any facts, other than the affidavit of Ms. Kanarick, which says at paragraph 6, that, quote, I understand through contacts in the equestrian industry and defendant Barrisone is in the process of attempting to sell several of his horses. That's all I've got. I don't have anything else in the record to indicate that there is a plan afoot for Mr. Barrisone to liquidate all of his assets and to relocate to some magical island in the Caribbean, or by way of analogy, anywhere else. The relief that the plaintiff seeks in this case is, in my view, and based upon my review of the very limited case law on this topic, it's extraordinary. Essentially, the plaintiff is asking for, although the plaintiff has not ridden the coattails of the statutes that apply to applying for and seeking and getting a writ of attachment, the plaintiff is seeking something functionally equivalent to that by essentially seeking a freeze order as to the defendant's assets, whether it be in the form of a receivership or a fiscal agent. Pretty much would have the same effect, and that would require a person or entity to be appointed to fulfill that role and to manage the assets of the defendant pending the outcome of the trial or other resolution in this civil case. There is, I understand, counsel can correct me if I'm wrong, there is a pending criminal prosecution against Mr. Barrisone at this time. My impression, subject to being corrected by counsel, is that Mr. Barrisone is presently incarcerated in pretrial detention, and he's not, unless I'm advised otherwise by counsel, my understanding is physically he's not going anywhere. Of course, that would not theoretically in this day and age in any substantial way limit his ability in and of itself to liquidate assets that he might have in the form of stocks, bonds, mutual funds, horses, real estate, whether he has real estate, other real estate in New Jersey or elsewhere, I don't know. Whether he owns horses, I don't know for a fact. All I have is a one-sentence proclamation by the plaintiff and her certification, which creates the innuendo that he owns horses. But horses, as we know, sometimes are the subject of investments themselves. Sometimes there are partnerships, joint ventures, or other more sophisticated investment devices that human imagination has created. So I don't know what Mr. Barrisone's got and where they are or how much they're worth. In the meantime, Mr. Barrisone, like anyone else, presumably has to pay his bills, legal bills, other bills that may come to his doorstep figuratively or otherwise. So the bottom line question is there any legal authority under the law for the relief which the plaintiff seeks in this case to be granted? In terms of modern case law, anything over the last 25, 30 years, really the only case law that's been cited to me is the Chancery Division case out of, I gather it's Atlantic County, or maybe it's Camden County, I'm not sure. Delaware River Bay Authority versus Hunter Construction. It's not binding on me, as counsel noted. Citation is 344 NJ Super at 361. It's a 2004 decision. But the judge in that case noted that particularly with reference to pages 368 and 369, in so many words, a claim for monetary damages in a civil action does not arise to the level of extraordinary harm or irreparable harm that an individual would suffer, for which an equitable remedy may be available and appropriate. Here, the plaintiff is seeking monetary damages, including punitive damages against the defendants, plural, including Mr. Barrasone. It is not at all clear that Mr. Barrasone is a ripe target for a writ of attachment. There's been no showing to this court as of this date, March 20th of 2020, to the effect that Mr. Barrasone is pulling up his stakes and moving his tent and his earthly goods to some other jurisdiction. So there's been no showing in that regard. The only whiff of information we have is something in the realm of rumor and speculation from Ms. Kanarick that she, quote, understands through contacts in the equestrian industry that Mr. Barrasone is in the process of attempting to sell several of his horses. This is, in my book, guesswork and speculation. It is secondhand, if not fourth-hand information in the possession of Ms. Kanarick, which is pretty much stale by this date, even if it was reliable. And the law in this area, as noted by the judge in the Delaware River Bay Authority case, is succinct and I believe still good law. And there the judge noted, I'm going to quote extensively from those pages that I just noted, as follows: damage, in quotes, sustained by the inability of the available remedy when provided to give relief is not the type of damage which our courts can address. Life is structured so that a litigant can't always get what is wanted. It's a polite morphing of the infamous line of the known and highly regarded non-legal scholar Mick Jagger: you can't always get what you want. The decision goes on to say equity should and does intervene when it can prevent the injury which would otherwise give rise to an action for money. It cannot and should not intervene to ensure that the money will be available. I'm going to stop and pause there. One can think of many situations where that observation is apropos and resonates. From my experience as a lawyer and judge, and perhaps counsel as well, one might immediately think of the civil action against O.J. Simpson following his vindication by a jury in Los Angeles County Superior Court some, 25 plus years ago. The chase for assets to satisfy the judgment which was obtained by the plaintiffs in the civil action, I believe, goes on to this day. They have had some modest success in recovering. I don't pretend to know whether or not there was an attachment or similar remedy available under California law that was imposed at that point. The decision in Delaware River Bay goes on further to state, quote, more than that, a prejudgment restraint against the dissipation of assets is functionally equivalent to a prejudgment attachment of those assets. The legislature has already provided for that remedy in certain very limited circumstances, delineated in the statutes providing for prejudgment statutes. NJSA 2A:26-1 et sec. No reason for expanding the reach of those statutes is readily apparent, especially since the legislature might have done so, but did not. On a practical level, any other result will have the effect of converting any money damage action against the defendant of questionable financial integrity into a chancery action requiring an investigation into the defendant's actual financial condition. It makes no difference whether the investigation is conducted in the law division as ancillary to the claim for money damages, or if it is conducted as the primary claim in a chancery action to which is appended a claim for money damages. That investigation will necessarily create a diversion from the central issue. Moreover, it cannot easily be limited. Once commenced, it will implicate questions of not only whether the plaintiff will ultimately prevail, but also, assuming whether plaintiff will likely prevail, whether harm will likely be suffered. This will, in turn, implicate questions of whether the defendant should be restrained from disposing of any assets or whether the restraint should be limited to disposition in other than the normal course of business. In short, the inquiry, once undertaken, will lead to a quagmire. While entering a quagmire is often necessary and a lack of definition, no reason to fail to do so, there should be some good reason and some theoretical underpinning before resources are committed. Here, no such supporting basis is discernible. The judge goes on to say in that decision that in the closely related field of receiverships, a majority of the courts considering the propriety of, and I quote, appointing a receiver for an entity to preserve assets to satisfy a future money judgment have refused to do so, noting the ALR article referred to at page 369. And quote, that result appears prudent. There's no reason to reach a different result when the request is to restrain disposition without the appointment of a receiver, unquote. So the problem as I see it, if I haven't already hit the nail on the head once, I'm going to hit it on the nail again, is that even though the liability issues might, from a spectator's point of view, seem very, very strong and powerful on the plaintiff's side, that doesn't necessitate or augur a quote unquote foregone conclusion approach that the plaintiff is going to lose and the defendant's going to lose and the plaintiff is going to prevail. Even if it did, then there's the other question of, well, what damages would the plaintiff be entitled to? $250,000, $500,000, $1 million? Should there be a limit on how on the amount of money or the extent of value of worth of the defendant's assets that should be subject to a freeze order or to a fiscal agent's control? And if so, under what circumstances should that freeze order or that fiscal agent appointment be subject to review by the agent or receiver to determine what bills should be paid and on what basis? It creates a whole second industry, if you will, as to what's involved if the court were to go down that rabbit hole. And the temptation, of course, is to now cite to Lewis Carroll, Alice in Wonderland, and all of that. So, counsel, in my view, there is no legal basis for the court to appoint a fiscal agent or a receiver at this point. Perhaps in the future there might be, but certainly the record factually is barren, and there's no factual basis for the court to grant this relief. And presently, I do not believe that there is a legal basis to grant this relief. Perhaps future events will warrant a different result, but based upon what I have before me here this afternoon, I find no basis to grant the relief. And so the application for the appointment of a fiscal agent as to Mr. Barrasone's assets is denied. I'll ask that Mr. Doninger prepare and submit an appropriate form of order via e-courts for the court's review under the 5-day rule.
Your Honor,
Thank you, Your Honor.
Your Honor, just want to make clear this is without prejudice. In case something comes up in the future, we can revisit it if necessary.
Yes, I think I've made that clear. It's without prejudice.
Thank you, Your Honor.
Okay, thank you, counsel. Have a good weekend. Be safe, be well.
Thank you, Your Honor.
Your Honor.